recorded. If anyone has any questions throughout the webinar today, feel free to type them in the chat box. I will try to keep an eye on that chat box. We are asking folks to, you can go ahead and type the questions into the chat box throughout the webinar. We're going to try to handle the questions at the end of the webinar today, just because we've got 4 different presenters and we're going to try to keep things moving today. We've got a lot of ground to cover. So thank you for joining us for the H2-A Visa Worker Program and COVID-19 webinar. I am Sarah Everhart. I work for the Agriculture Law Education Initiative. If you're unfamiliar with our organization, we're a partnership of the Francis King Carey School of Law at the University of Maryland, Baltimore, the College of Ag and Natural Resources at the University of Maryland, College Park, and the School of Ag and Natural Sciences at the University of Maryland, Eastern Shore. We are an Empowering the State program, and we have a website that houses all of our resources. So if you've never checked out our resources, I encourage you to do so. We do have H2A employer resources, and we have COVID-19 resources as well. So I'm going to be kicking things off today as the first speaker. We also have Nick Fiorello and Brian Belcher from the U.S. Department of Labor. And so I am excited to hear from them today, and thank you, gentlemen, for joining us. And we also have Carlos Tuchios from the Division of Workforce Development and Adult Learning. He's the Acting Rural Services Coordinator for the Maryland Department of Labor. So thank you, Carlos, as well. Okay, so I said we were going to be ambitious today, and we are. We're going to cover quite a few topics related to this. I'm going to start out just sort of going over a few of the COVID-19 related changes to the H2A Visa Worker Program, how H2A workers are impacted by the Families First Coronavirus Response Act, and then quite a number of things here. What employers should do if the workers will be arriving late, how to claim contract impossibility, how to transfer workers to another employer, how to file an emergency H2A application, how to deal with workers if they need to be restricted because of COVID-19, how will a COVID-19 related reduction in hours impact the 3/4 guarantee, and then finally some details on the job order process and housing for workers during COVID-19. So, recent changes to the program. Most of you know this, but just sort of to set the stage. So as of March 20th of this year, the U.S. Department of State temporarily suspended routine visa services at all U.S. embassies. Then on March 19th, the USDA and the Department of Labor announced a partnership to identify foreign and domestic workers that may be eligible and available to transfer to other agricultural employers throughout the U.S. And so I provided you with the website there. And so if this is something that you need, I encourage you to check out that website. Important to note that employers are still required to file a job order in the Maryland Workforce Exchange, an application with the Department of Labor flag system, and a petition with the Department of Homeland Security. And just a word about the links. I'm happy to email this presentation to anyone who wants a copy of this following today's webinar so that you can click on these links, because there will be some hyperlinks throughout today's presentation. On March 26th, the State Department, in consultation with the Department of Homeland Security, expanded the categories of H2A applicants who could be adjudicated without an in-person interview. So consular officers, can now, if they choose, waive the visa interview requirement for first-time and returning H2A applicants who have no apparent ineligibility or potential ineligibility. And then this was sort of the most significant change. On April 20th, the Department of Homeland Security published a rule in the Federal Register, and it enacted quite a few changes. I'll give you a couple of the highlights. Employers will be able to petition to employ foreign workers who are already in the U.S. and H2A status, but working for another employer who no longer needs their services. These workers will be able to start working for a new employer upon the new employer's filing of an H2A petition, And the new H2-A workers will be allowed to stay in the U.S. Beyond the 3-year limit. So this rule was published on April 20th, like I said, and it is currently effective through August 18th, 2020. It may be extended for a period past August 18th, 2020, but at this point, that is the term of the validity, so we'll just have to keep our eye on that. Okay, and after that overview, I am now going to pass the baton to Nick, who's going to take over for the next couple slides.
Okay, thank you. So I am going to give a bit of a brief or an abridged version of an explanation of the Families First Coronavirus Response Act to kind of tailor this to your area or in the H2A context. Essentially, this FFCRA Act was passed in March, and it became effective April 1st of this year. It is requiring paid sick leave and an expanded Family Medical Leave Act for covered employers. In this context, I'm not going to talk too much about the expanded family medical leave because that's not going to be applicable, or it won't. I don't think it'd be very common in your industry or in this industry. So I'm going to stick mostly to the paid sick leave requirement. Essentially, the act applies, or employers are covered if they have fewer than 500 employees. And there is an exception that a small business can claim when they have less than 50 employees. So the first thing we're going to look at is the coverage aspect and counting employees. So as you can see here, full and part-time employees are counted, and this is for both determining having less than 500 employees and any applicable exemption so you're able to claim if you have less than 50 employees. Temporary employees are counted, day laborers are counted, and employees that may be jointly employed between two different entities are counted. The count is made specifically when an employee is requesting paid sick leave. So there may be a time where you may have more than 50 employees at a specific time when one specific employee is requesting paid sick leave. And there may be another time where you could have under 50 employees. So this count is specific to the day or the request, or when the request for the leave is initiated. There is a notice requirement. You're required to, covered employer is required to have a poster. It can be distributed online, as you see. It could be emailed or mailed directly to employees. Only covered employers are required to post the poster. So if you have less than 500 employees, you're required to have the poster or post the poster. If you are claiming an exemption because you have less than 50 employees, you're still required to post the poster or distribute the poster because you are a covered employer. So there are essentially 6 qualifying reasons. And again, I'm going to mostly concentrate on the first 3, which are most applicable in this context. An employee is entitled to take leave when they're unable to work because, as you can see, the first qualifying reason would be an employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. The second qualifying reason is that the employee has been advised by a healthcare provider to self-quarantine for reasons related to COVID-19. And the third qualifying reason is the employee is experiencing COVID-19 symptoms and is seeking a medical diagnosis. These are the other three reasons on this slide that an employee may be eligible. Again, these three factors are a little less likely in this context, but just to briefly talk about them, an individual is caring for, or an employee is caring for an individual who's subject to a stay-at-home order, for example, or because the individual has been advised by a healthcare provider to self-quarantine. The employee is caring for a child whose school or regular childcare provider is unavailable. And then the sixth qualifying reason is the employee is experiencing any other substantially similar condition. Number 6 is not applicable right now. There isn't, and to my understanding, any other substantially similar condition that's been specified by Health and Human Services. And that's why that's not too important. In the future, if something does come, that's kind of possibly a catch-all for that, for any possible future condition. So to talk a little bit about the small business exemption, what's important here is that there is no application process specifically, and this is on the small business or on the employer to demonstrate that you qualify for the exemption. Again, there's not a process for applying with Department of Labor or Wage and Hour. The employer is not required or should not send any kind of documentation to Department of Labor unless the Department of Labor, Wage and Hour initiates an investigation. So the employer is required to document and maintain appropriate records demonstrating the qualification for the exemption. And these listed on these slides are what would be applicable. You can establish that the leave would jeopardize the viability of the business through providing for the leave would result in expenses and financial obligations exceeding available business revenues and cause the small business to cease operating at a minimal capacity. The employee's absence would entail a substantial risk to the financial health or operational capabilities of the business because of the employee's specialized skill and knowledge of the business or responsibilities. Or the third one, and you notice the or there, which is important, is there are insufficient employees able, willing, and qualified at the time, place needed to perform labor or services provided by the employee. And these labor or services are needed for the business to operate at a minimal capacity. So again, one of the three is what's sufficient. You don't have to claim all three of them in order to claim the exemption. And this is going to be a very specific employer by employer determination that must be made. So the basic benefit, again, concentrating on just the emergency paid sick leave aspect, is there's 6 qualifying conditions. The first 3 are the most applicable in this circumstance we're talking about. An employee is entitled to a 2-week period of time up to 80 hours, and 80 hours is the cap. And a part-time employee is entitled to a prorated amount of that leave, depending on what their normal work schedule is. What's important is that during the leave, a continuation of applicable health insurance needs to be maintained. There's the required rate of for time when employees are taking the leave is the highest applicable of any of the following 3: the employee's regular rate of pay, the Fair Labor Standards Act minimum wage, or the highest applicable state or municipal minimum wage. So in the H2-A context, that would be the AWAR rate. Again, the cap is 80 hours, and it's, again, prorated depending on the amount of time that a part-time employee may have worked. You can look back up to, I believe it's 6 months to determine the employee's average amount of time in the previous 6 months period to determine what a part-time employee may be entitled to. And again, the cap being 80 hours. So for the first 3 qualifying reasons, an employee would be due 100% of the required rate of pay for the leave up to the 80 hours taken for any of these 3 qualifying reasons. And again, these are the most likely qualifying reasons for to take paid sick leave in this context. The total pay is capped at $511 per day for a total of $5,110 is the maximum. The other 3 reasons that were discussed briefly a little earlier, again, just for knowledge, not that they're going to be very applicable or not likely to be very applicable in this context. The reasons 4 through 6, that it's at a 2/3 rate of pay. So the total pay there is capped at $200 per day, or a total of $2,000 for the entire 80 hours.
Hi, everyone. This is Brian Belcher, and I wanted to talk to you with Wage and Hour, and I wanted to discuss a few of the issues in H2A employer obligations that I'm sure many of you are aware of, but we want to emphasize the fact that these obligations are still in place even in the current situation and challenges that you're facing at present. So I want to go through a few of these just briefly and let you know some of the more common issues that we see as an enforcement agency when making on-site compliance checks and investigations under the H2A program. The first of which is disclosure, making sure that all covered workers, both H2A workers and workers in corresponding employment, are provided with proper disclosure of the terms and conditions of employment at the proper time. So for the H2A workers, that would be before they are traveling to the United States, and that would be at the time they apply for his or her visa. And then for corresponding U.S. workers, it has to be provided no later than on the day that work commences. So just making sure that workers are provided with all the information they need to decide whether or not to accept that position and what they'll be doing, the hours they'll be working, the wages they'll be paid, and so forth. The next bullet point talks about wage requirements. As you're aware, there are minimum wage requirements under the H2A program, whether it be the adverse effect wage rate, perhaps a state minimum wage, or another promised wage, such as a piece rate that may be disclosed to the workers. Those are still in place and are required during the contract period and any extensions for covered workers. The H2A program has a 3/4 guarantee of the hours that are offered. It must be offered to workers under the H2A program. There has been some discussion about that, which we'll probably get into later in this presentation. Whereas if workers are not able to work or something happens where they're quarantined, as was previously mentioned, to make sure that employers note the reason why workers were not working and what the circumstances were. So keeping good records of those situations and any special situations that you deal with is very important. The housing requirements, H2A has in it housing safety requirements and an obligation to provide housing to workers under the H2A program, and making sure that that housing meets the applicable safety requirements. Those are still in place. And our sister agency, the Employment Training Administration, has issued some frequently asked questions which deal with the process for finding alternative housing if the housing that was certified becomes unavailable for circumstances related to COVID-19. The meals under H2A, there's a requirement to either provide meals or provide kitchen facilities for workers. So that is something that is still in place. It is an area that we often find issues with, whereas what is disclosed in the contract may not be followed, or an employer may try to give a stipend as opposed to do one of the approved and regulatorily allowed meal plans. So just making sure that employers do what is stated in their contract. With transportation, that is to make sure that employees are properly provided with safe transportation to and from the work site, as well as making sure there's proper insurance, licensed drivers, and what have you. There are also requirements for providing inbound and outbound transportation and when those amounts must be reimbursed or paid directly. So just be sure that for anyone that is subject to these contracts, that they are provided with safe transportation that meets all the requirements and the regulations. Preferential treatment describes making sure that there is no preferential treatment for H2A workers over other U.S. corresponding workers. So some examples of that are if a H2A worker will pay a higher wage rate than other U.S. workers for the same type of work. That would be an example of some type of preferential treatment, or having them have preferential job site locations, work activities, and things of that nature. So just making sure that U.S. workers are treated as good as the H2A workers that may be brought in to work on a contract. There are other assurances and obligations, things like a requirement to contact former U.S. workers to make recruitment during the recruitment process to try to find workers before H2A workers are brought in. And just wanted to issue a reminder that everyone make sure that they're aware of what they're signing up for in the H2A program, what those obligations are, and also to let you know if you have any questions about that, Wage and Hour has extensive material available on our website under the agriculture program and specifically H2A that provides a lot of good information. Also, our district office in Baltimore, which handles the majority of the state of Maryland, they also have staff available to answer questions, and you can certainly contact them with any specific scenarios that you'd like to go through or questions that you may have. And the last point is about record keeping. It's become vitally important, especially in these times, that proper records be kept, not only of the normal things that you may be used to, like hours worked, hours offered, rates of pay, deductions from wages, wage statements, and things like that. But also, if you have special circumstances where perhaps you have to house workers at an alternate site, or you have workers who are delayed arriving or are not able to work because of quarantine orders or a business shutdown or something along those lines, it's vitally important that employers keep records of the circumstances and what happens for consideration. We would want to look at those records and make sure that things were kept in accordance with the regulations and explain any special scenarios that may happen. Thank you.
Good afternoon to all the farmers and guests. My name is Carlos Tercios. I am an employee for you through the Maryland Department of Labor. First and foremost, I'm grateful for the opportunity to be online with you. I also like to note, please do not consider this as legal advice. I'm not an attorney. I'm also not a physician. However, I have learned some of the common questions that we have here that were provided to us. So I'll be going over about 6 or 7 items. So the first question that was given to us is, what should employers do if their workers are arriving late? As Brian has already stated, record keeping, this is definitely a record keeping scenario. What I did here is I copied the reference from the Code of Federal Regulations. So please make sure you keep accurate, adequate records with respect to your workers. It may say here, you know, record the time offered to the worker, but which the worker may have refused, quote unquote. If COVID-19, since this is a topic surrounding COVID-19, the worker is not necessarily refusing per se, but they're unavailable. And if it's due to disease or because they have not had a chance to enter the United States, then it's highly recommended that you keep a record daily of the status. So then that way, if there's any question later on, you can recall quickly in a written document why, who, what, and where. There's also...
Carlos, can you speak up a little bit? It's a little hard to hear you.
Forgive me. Is this better? Is this any better?
It's a little better.
Sorry. I will try my best. Please feel free to interrupt if I'm not communicating yet. So again, just to restate, please make sure that you keep a fair record, especially daily, if your worker has not arrived on time for the temporary labor certification. As Brian mentioned, or I believe it may have been Nick, there is frequently asked questions available through the United States Department of Labor. There is a link here, and as Sarah mentioned, we should be able to send those to you later on. Moving on, it was talked about whether or not COVID-19 has impacted whether it's your business model, possibly your worker, if it's a disease that they're suffering. You have to make sure that you communicate with the certifying officer with Chicago National Processing Center. If you're going to claim a contract impossibility, you'll need to state the details why this has impacted your business, why you're not able to meet the full extent of the contract once you're certified. And if you don't have reasons, if you don't have proof, it'll be difficult to understand why you were not able to make the contract. So you need to communicate with them. I say here immediately, that is within reason, within your power to communicate that after you've made that evaluation. There's also a frequently asked question on that. I cite that it is an act of God. It is not due to fire or weather. So I hope that makes sense so far. The next question that we were given is how to transfer workers to another employer. Professor Sarah was able to share with us earlier. The United States Department of Agriculture already has a large database. It's public source. So just want to highlight that right now it is for all job orders ending by the end of June. If you were to go on there, the last time I checked, you will actually see a Maryland farm that has been certified. And so you can tell that it is in real time and it is true information. Another source, if you're not able to check the Excel spreadsheet from the Department of Agriculture, United States Department of Labor already has a seasonal jobs.dol.gov. And so you can actually go in there and you can filter it for specifically agricultural positions since it's H2-A related. And you can also look for other employers, whether within the state or in other areas. So I have provided the link there. It should be pretty accessible. You can also get in touch with us in case if you need to find that. How to file an emergency H2-A application is pretty much the same way that we file other applications. We still use the Foreign Labor Application Gateway, i.e. FLAG. And so you just have to make this statement, there is an actual option in the flag system when you can select whether it's for an emergency application or not, given the time frames. And so even though it isn't on this slide, I will highlight that you need to have your flag application not less than 60 days. So if you're going to use the emergency H2-A application, then you'll have less than 45 days to have turned in both the 790 format and the 9142 form. However, there is an or statement, whether the request is for good and substantial cause. And so here I highlighted that if there's pandemic health issues, that is actually already written in the regulations. So there is no innovations here. This is all already created in the Code of Federal Regulations. And so if it is for the reason that your workers in the United States are not available, and here again, it's not weather-related activities if we're focused on COVID-19, and so you'll have to keep a very good explanation in detail why you would need to exercise your emergency H2-A application option. So again, as I mentioned earlier, I am not a health department employee. However, all of that information is publicly available for everyone, and I can also direct you straight to it in case if you need those items as far as guidance straight from the Maryland Health Department. So if a worker needs to be restricted regarding the type of work, because they are critical infrastructure, so this is federal mandates or federal guidance that the food and agriculture sector is considered critical infrastructure. So for workers, whether they are U.S. workers or H2A workers, there is guidance through the health department. I'm not sure if I'm able to pull up the actual guidance from them and share it with you on this presentation. However, this link here in blue for Maryland Health Department, it goes through virtually each scenario. So social distancing is still applicable. Face coverings are still enforced today. I know that we are expecting a safe at home order tomorrow. However, you still have to have your employees wear a face covering, a mask, and basically keep the social distancing 6 feet, 2 meters. That needs to continue to happen until we've received the all clear. So if you have exposures, I will mention here, if there's an exposure that you're aware of, you have the nucleic acid test and it comes back positive. And I know I'm kind of pushing a little bit ahead with respect to the housing. You'll have to make sure that if that happens and your workers are basically with you at your work sites or at the housing when they're resting, possibly eating for their lunch or dinner, you'll need to make sure that isolation and self-quarantine happens. It has been mentioned earlier on the COVID-19 and how to exercise leave for your employee for their benefit. So just, again, in a sense, it's a record-keeping scenario where you're going to need to make sure it's in clear detail, especially who it is, who the individual is, and not to violate HIPAA or health information, but more or less to make sure you know who is sick and who is not. And so the 3/4 guaranteed is still in place. So if COVID-19, this question, when I read it, I had to think about it on two sides. So when I read how will a COVID-19 related reduction in hours impact the 3/4 guarantee? So if it's with respect to your business model, meaning that your consumer, your contracts, if you had basically a future contract with a consumer and that has been impacted by COVID-19, then you'll need to make sure that that is referenced for, per se, a contract impossibility. I also had to look at it not only in the sense of the business suffering an economic disadvantage. If the employee, if your labor hours were reduced because they were not able to work, not necessarily a refusal to work, but the inability to produce those labor hours for your work site, you'll have to keep that, again, in a fair record. So then that way it can show for the record, excuse the repetition, it can demonstrate to any other official later on why that individual was not able to basically receive the benefit of the 3/4 guarantee. And so, once again, this question is, to me, it can impact both sides, whether it's the business model or if it's your labor that is suffering the COVID-19 disease. Professor Sarah already mentioned that you need to continue using Maryland Workforce Exchange. The job order process has not changed in the state of Maryland. We don't have any other system. You can email my colleague, Jesus Diaz. You can email me. Our email addresses are available to you. We can send them out again to any audience on here. If you aren't already participating in H2A, we would greatly enjoy getting to know you and seeing if we can offer you any resource, even if it is not for H2A, because the job order process is open to any employer. I will plug again Foreign Labor Application Gateway, which is the United States Department of Labor application process. It's the H2A certification process. That has not changed. It is still in place. The housing inspections, my colleague and I right now, we have been pretty much given the privilege to travel the state. We're not doing alternative housing inspections. I will mention here, I do not have access to office, to any Maryland Department of Labor office, so we won't be able to print anything. Some employers have asked for their records, and so we've kept notes, strict notes, and we plan to, as soon as our offices are reopened, we plan to provide you, we use the standard ETA 338 form, and so then that way you have your record later on in case if anyone needs to review that. And so I put here, please cooperate with the SWA, which is, in our case, Maryland Department of Labor. If in case you have alternative housing post-certification, you need to let me know. You need to contact whoever may be your business resource rep if you're working with someone locally in your county. And so we just need to know. You can email us. You can call us. We do prefer emails because, again, our offices are closed. We may not be able to hear that voicemail. I'll give you my cell phone number in case if you need me. And so we will continue to inspect housing. If you have to add any more housing, if you have to change the housing. And so we're still trying to meet customers' demand, and we are still doing our best to deliver Governor Hogan's customer service promise. And so I have here, at least for your reference, another frequently asked questions. There were about 3 rounds of FAQs that the United States Department of Labor has given us basically public access. We can all read them and see. We pretty much have had the same questions, not only in Maryland, but throughout the states. I hope that makes sense. And again, I really hope everyone is healthy, stays motivated, and I really hope to see you all real soon. This is Carlos. Over.
Thanks, Carlos. Yeah, so as Carlos was mentioning throughout his presentation, these 3 rounds of frequently asked questions are a really good resource for a lot of these issues. And I would think that as the summer plays out and people, have more questions and the Department of Labor is giving more answers, there could potentially be more rounds. So I would definitely keep that bookmarked on your computer or wherever you keep sort of frequently looked at sites. I included a few more things here, but you know, I will share the presentation with everybody so that they can access the other links, and keep in touch with us if you have more questions. I wanted to provide everybody's email addresses so that you could have those following today's webinar. Gentlemen, we did have some questions, so I'm going to read these questions from the chat box. So, what is being done to get workers here from other countries other than host countries, such as Honduras, whose borders are closed to non-immigrant travel out with the exception of with a U.S. citizen? Anybody want to take that question?
Hi, Sarah. Can you hear me?
Yes, I can.
I have a vague idea. I know that my colleague has been doing some research. Since we really can't speak too much on State Department level policies, but that's really something, you know, COVID-19 being the crisis, this has all been brand new policies enforced, and embassies and consular officers are having to react is the only word that I can come to mind. So as far as that, I think they would have to make sure that they're speaking with the host country, the American consular office in that host country. If they haven't reached out yet, recommend that they need to try. There is phone numbers that you can call down there. You may not get the exact person that's going to deal with the appointment. And as far as travel, if one government has their policy, we really can't speak to it other than, you know, that's they're their own sovereign nation, and we can't bend anything there. That's really much past Labor Department, if that makes sense.
All right, a few more questions. So if you've already petitioned for visas from a specific country, how do I change that petition for people already in the U.S. or to another country that is letting people travel out?
Sarah, this is Carlos again.
Mm-hmm.
So I guess if I could see that question, or if I understand it correctly, is it about changing the country of origin?
Yes.
That's it, to my humble knowledge, that's a Homeland Security question, because Labor Department has there's no question from the Labor Department in terms of the origin of your H2-A guest worker. That's a Homeland Security I-129, and I believe, in my humble knowledge, I believe you can amend that. You can change that I-129, and that is something, again, publicly available. So that's through Homeland Security, because if you need to change the consulate, and you have to notify California or the office in California where H2-A applications are processed for Homeland Security.
Okay. Another question. If we kept 2 of our workers separate from our other workers for 2 weeks after they arrived to ensure they were symptom-free, are we required to pay them for the hours they didn't work?
So this is Nick. In the realm of FFCRA, and you may need to repeat the question, but to my understanding, if the question is the employer is making the decision to quarantine the worker, and it's not on the advice of a healthcare provider, for example, and the employees themselves are not exhibiting COVID-19 related symptoms, then that wouldn't fall under the FFCRA, and there would not be a paid sick leave requirement. But there would also be a bit of a concern, an intersection with, a concern with hours offered and guaranteed hours that I can't really speak to.
And Sarah, I can piggyback on that regarding the H2A requirements. Still the same protections that are in place under the H2A requirements for hours offered, making work available, and what have you, are still in place even in the current circumstances. It would be important, however, as we've all noted, that employers, if they are having workers that are not working, not able to work, whatever the reason may be, because of a quarantine order, because of their own sickness, whatever the circumstances are, consistent with the record-keeping requirements, that they note the workers, what they were doing, and if they were not working, let's say the employer had hours available to offer, that they noted why the worker did not work or was not able to work as part of their record-keeping requirements.
Okay, thank you. It looks like we have Kathy wants to ask a question. Wait, just one second. Carlos we can plug this as well. Okay. Thanks, Carlos, for sharing that. All right, Kathy, I'm going to unmute you if you want to go ahead and ask your question.
Sure. I was just wondering, we have two workers from El Salvador, and if there's a second wave of the virus in the fall and they're not able to return back to El Salvador, how would we be able to extend their visas, or how do we do that? Is that possible?
Good afternoon, Ms. Cassie. This is Carlos. That's a very, very good question. To my knowledge, you would have, if the decision is that you will have more work available because you're going to extend your certification, that would be one thing. Generally, from my experience, you can petition for about 2 weeks to 30 days on the end date. But this scenario now, it seems like, because of a pandemic issue, and I do know that there is some extensions that they've made, I think, and I don't want to step on anyone else's toes, maybe if, not to put Brian or Nick on the spot, I think it may benefit, and again, this is up to you and how you're going to do this, if you can possibly, I say exchange, really to transfer your worker to another H2A certified employer in the United States. But if you're saying to extend it on your own application, Homeland Security and Labor Department generally has, I say, a small margin that you're able to extend the work contract. Hopefully that makes sense.
Yeah, Carlos, just to piggyback, since you mentioned wage and hour, is our role of enforcing the actual contract provisions, we would look at the contract period that was in place and any approved extensions to that. The question about whether their visas could be extended or the work contract could be extended, what have you, that's all part of the process that I'm sure those other agencies already have in place. And I'm sure they have conditions under which certain things can be extended. So I think that they just have to follow whatever those agencies' processes are for extending a visa or for extending your work contract if needed. It's a good question. And I think, as Sarah alluded to earlier, I would expect that as more questions arise and things happen like what you're mentioning, that additional information will likely be provided as we progress through this.
Okay, we got a follow-up question to that. what if we don't want to extend the contract, but the workers are not permitted to go home?
So if I understand that you're saying that their country of origin is not going to allow them to travel back, is that the question?
I think that's the concern, yeah, that the contract at the farm would be over, but the workers wouldn't be able to re-enter their countries if there was a second wave of COVID in the fall or winter.
That's a difficult scenario, because and again, all due respect, if that individual business may not have any additional work, if their season is in fact over, I mean, I'm not suggesting that people start tourism visas, but that is such a macro question. I wouldn't know how to. I'd really. I think I see the question, but I don't have the accurate answer for that. So I apologize.
Yeah. Do you all have some contacts at Homeland Security or the State Department? Who would be the right, do you think you could maybe pass on an email or a contact for some of these questions that seem to be outside of our realm of expertise?
Hi, Sarah. This is Carlos again. So at least from Team Labor, we don't have any direct contacts. I have guided an individual business in the past on how to get to the help desk with California, the Homeland Security Office.
Mm-hmm.
So those are they do exist. There is ways that you can get a live, you can actually speak with someone from Homeland Security, and they'll accept your questions if they don't have it as an answer right away. They will get back in touch with you. From my humble experience. Now, State Department, that honestly, again, you'd have to go to that, I don't want to say chief of mission, but you'd have to look at their policies, review that. And again, I believe there are phone numbers that you can call down. But again, that's within American State Department.
Right.
If the question is with a foreign government, that's completely outside of Labor Department.
Right. Well, if you could pass this on to me, Carlos, I will. I'll put that information in the email that we send everybody following the webinar, so at least they have the right. They can attempt to get a human being at the agencies that they need to talk to.
Of course, yes, ma'am.
Is there any other questions for our panelists today? I don't see any, so I want to thank the panelists for pulling all this together. It's really appreciated, and thanks everybody for attending the webinar. You will be hearing from me with the recording and a version of the PowerPoint that will allow you to access the links. And feel free to stay in touch with us as questions or concerns arise throughout the growing season, and we will try to address them as best we can. All right, thanks everybody.